Good morning, Justice Ramesh and Joshua. Thank you for joining us today. Let's get right into it. We know of some virtual hearings taking place, but at the same time, other hearings and courts processes continue to be carried out in person. Now, this may be a broad question and we will go into the specifics later, but Justice Ramesh, what are some of your general thoughts about how COVID-19 has impacted the courts and the ways in which hearings are conducted?
Well, first and foremost, it's a pleasure to be here. Thank you for inviting me. It's so nice to engage with future practitioners in discussing what is very topical and what I believe has changed the world. We will see the ramifications unfold in the coming years that COVID-19 has brought. But turning to your question, let me answer the question by referring to an article published in August this year by Professor Richard Susskind for Harvard Law School's Center on the Legal Profession. Professor Susskind observed that within days of court buildings around the world closing in March 2020 in response to the pandemic, the uptake of various technologies, especially video, was accelerated in the justice systems of numerous countries as part of alternative ways of delivering court services. He noted that, and I quote, "Until a few weeks ago, most judges and lawyers rejected the idea of non-physical courts, denying that remote hearings could be fair or even technically feasible. Then the virus came, courts closed, and only took a fortnight." Professor Susskind argues that this shift in mindset has led to greater acceptance by all stakeholders that judicial and court work might be undertaken differently. He cited a survey by the Bar and other stakeholders by the Civil Justice Council of England and Wales of their experience in relation to 480 civil hearings. 71.5% of the respondents described their experience as positive to very positive. One finding in particular is of interest. Despite early reservations that remote courts might impede open justice, many reported that video hearings were in fact more accessible than conventional court hearings. I don't think our experience, Singapore experience, has been any different. The pandemic has certainly influenced the way the courts have gone about their business here. With the circuit breakers, physical hearings were not possible. Everyone knows this. The courts therefore announced on 5th April 2020 that only essential and urgent hearings would be heard, and that too remotely. Physical hearings resumed with the lifting of the circuit breakers. However, Registrar Circular number 3 of 2020 provided that hearings would largely be conducted electronically. In fact, that in many ways has become the default mode. Many matters today, particularly those that do not involve trials, continue to be heard virtually. Safe distancing protocols are imposed for all hearings, remote or otherwise. In fact, it has all worked out quite well for us. Seeing as how everyone has adjusted so well, Professor Susskind asks rhetorically, do we really need to congregate on all occasions in a physical setting? He argues that we do not. I think there's much traction for his argument. Virtual hearings are here to stay, in my view. The technology has proven its worth during the circuit breakers, and it will only get better. User experience has been positive, which will only mean that phobias are being overcome and consigned to the scrapyard. As familiarity with technology increases with greater acceptance and use, there's every reason to believe that this will be the new normal. The Chief Justice, in fact, has the same view. He said, and I quote, "I join the growing chorus of predictions that the conduct of hearings by way of remote communications technology is likely to become commonplace and perhaps even the default modality for most hearings." Unquote. I make two further points. Excuse me. First, the pandemic, to use the Chief Justice's word, has been a watershed in the partnership between justice and technology, particularly in the use of video conferencing technology, unquote. But this is just the start. I think the courts and the profession must harness the momentum that this has generated to reimagine even more fundamental ways in which court and legal services can be reshaped by technology. Second, as a related point, we need to re-examine the relevance of long-standing practices of the courts and the profession, such as the liberal use of hard copies and multiple bundles, and the tendency towards lengthy oral submissions. A concerted effort to control and contain the universe of information before the court and to embrace the latest document management software and techniques would represent progress in my view. At the same time, crisp written advocacy, allied with sharp and succinct oral advocacy, will, I suggest, lend to more effective persuasion. There's one word of caution, however. As we embrace the exciting world of technology and are swept forward by its wave, we must ensure that technology does not make the playing field uneven or impedes access to justice. If a litigant is advantaged or disadvantaged as a result of technology, that goes against the very grain of the rule of law and due process. If technology impedes access to the courts, that is an access to justice issue. These are fundamental points that go to the fabric of our society. In this regard, the judgment of the High Court of Durban in South Africa in Union Swiss Proprietary Limited and Govinda is worthy of consideration. Thank you.
Thank you for that, Justice Ramesh. And just building on that point on how virtual hearings are here to stay, our second question is for both you and Joshua. And we wanted to ask whether there are any significant differences between virtual hearings and hearing trials in person. So for instance, whether unfamiliarity with video conferencing platforms or connectivity issues and the like have impeded courts in any significant way.
Well, I think unfamiliarity and connectivity issues can be dealt with in trial runs, test runs, and having a proper plan B in the event you have technical glitches. And I always, in my matters, and Joshua will know this, having worked with me, insist on these very strictly. But there are differences between virtual and physical hearings. I mean, that is a fact. Virtual hearings present certain unique challenges. I name a few. First, security and privacy is different. Those are different considerations. Second, there is Zoom fatigue. Virtual hearings are certainly more tiring and require more breaks. Third, document management is more difficult. One simple example is the introduction of documents at the very last moment. In a physical hearing, you just turn up and produce a document. You can't do that in a virtual setting. Fourth, technical matters can unsettle and disrupt. So they need to be fully sorted out beforehand. And as I've said, trial runs and a plan B are critical. Plan Bs are important because technology can let you down in the course of a hearing. So you need to have an option in the event that happens. Fifth, the modalities for interaction between the court and counsel and between counsel have to be provided for. How do you interrupt in a virtual hearing? How do you register an objection? How do you read the court's non-verbal cues? It's all quite different in a virtual hearing. So there are differences and you will have to adapt.
Yeah, so I'll jump in at this point. I think Justice Ramesh has rightly alluded to it in our work together, and I think in the work of the court in general, it's there are issues of preparation and execution. So first on the point of test runs, which is the preparation aspect, I think there are two aspects to this. First, if you observe any of the high courts or Court of Appeals proceedings today, you see prior to the hearing, and of course before the judge enters, the manager or private secretary of the judge or the JLC will set the Zoom room up. And at this juncture, we'll try to resolve any issues with connectivity, functionality prior to the formal commencement of the hearing. And of course, the second facet to Justice Ramesh's observation on test runs, of course, and this is probably not visible to the courts, it extends to actions on counsel's part prior to proceedings. And I believe, and as we have been able to see on screen, many firms have started adopting their own SOPs. They set up in meeting rooms subject to safe distancing measures. And so the idea of all these steps taken is to ensure that avoidable problems are avoided and dealt with way in advance. And of course, fortunately, platforms such as Zoom, they do give us prophylactic plan Bs. And I'm sure most of us will be familiar with the interface by now, but there are multiple functions for rooms, holding rooms, backup rooms in the same account, backup accounts. So I mean, these are just some of the steps, the methods that the platform has afforded to us and which we have exploited. And these may be very easily accessed should anything go wrong in the course of a hearing.
And on the flip side to that, have there been any incidental benefits to virtual hearings? And what role, if any, might virtual hearings play in how the courts operate in the future?
I think the benefits are obvious, and that speaks to why I believe virtual hearings are going to be permanent fixtures. I cite two examples. There are several, and there's a lot of literature in this area. First, virtual hearings encourage and indeed compel us to embrace technology in every facet of the litigation process. This surely must promote efficiency and lead to the reduction of costs. So that's an obvious benefit from the litigation process. Second, and this is perhaps a strategic benefit of strategic relevance, allowing for virtual hearings means hearings may be conducted from anywhere. This is a plus for counsel and witnesses, as the need to travel to a physical hearing is no longer an imperative, subject to, of course, jurisdictional considerations. If you're testifying from another jurisdiction, there could be certain sovereignty issues. Allowing for virtual hearings from anywhere in the world, or from any location, may very well suit Singapore's objective of serving as a hub for the resolution of international disputes. This is not a phenomenon without precedent. COVID has seen international arbitration disputes being heard remotely, with arbitrators, counsel, witnesses, parties connecting virtually from all parts of the globe, time difference notwithstanding. In fact, there have been instances where arbitrators have been hearing matters in Asia while they are located in North America. So you can imagine the time difference is significant. In fact, the SICC, the International Commercial Court, has itself conducted virtual trials. So it's very, very possible that this can become operationalized in a regular way. I too recently conducted a remote trial sitting as a judge of the Brunei Supreme Court. The court, that's me, counsel, and some of the witnesses were all located in different jurisdictions. So technology makes so many things possible. Right? We just need to make adjustments to cater for the operating environment.
Yeah, I had the pleasure of assisting Justice Ramesh in one of the matters involving virtual witnesses across various jurisdictions. And in fact, this was in the period, or rather it spanned a period after and even before the circuit breaker measures. So in that respect, it's actually interesting to see how that has gone from novelty back then to a norm these days, really a sign of the times. I think Justice Ramesh has already mentioned some of the benefits and downsides and like the intricacies involved when we're dealing with virtual cross-jurisdictional matters. I'll just add a few more brief observations. I mean, on the point of travel and time savings, absolutely. And I believe any practitioner today will tell you the same. So prior to COVID, the areas outside the bulk hearing courtrooms and the registry in the Supreme Court, they're always chock full of waiting lawyers. And you see people waiting for hours on end for their turn outside of the comfort of their office. And they might be working on a laptop or something, but certainly it's not particularly comfortable. But now when I walk through the court building, it's rather empty, and understandably so, because as Justice Ramesh pointed out, many of the hearings have shifted online. Counsel can continue working while waiting in their home offices, and the waiting is done in the virtual waiting room. And so, it makes for efficiency because they can continue with their work. And as and when they're called upon, they can switch on their camera, be ready to go. And yeah, so that's the practitioner's perspective. From my perspective as a law clerk the past 12 months, I can say one incidental benefit, and this is in the course of hearings, is noticeable in terms of document management. So we often have to multitask during hearings, referring to documents, displaying documents for parties in the court, taking notes, minuting, and generally assisting the judge that we are clerking for. And the multitasking, I find, has actually been made easier by the remote setup, given that we have multiple screens to refer to, etc. And that infrastructure is not necessarily available in some of the courtrooms because of space limitations and whatnot. And in particular, I highlight the screen sharing function on Zoom, which actually has been used in several online proceedings. It allows for everyone to focus on one document, in fact, the same part of the same document. And it has the added benefit in the substantive hearing of making it patently clear what exactly parties or witnesses have said. This no doubt discourages attempts at obfuscation or the like. And I think a final related point, on the note of screen sharing functions and their benefits, the Supreme Court presently actually has two tech courts. These are courtrooms which possess integrated display capacity, smart screens, where the judge, the JLC, or the parties can control. Big screens everywhere. And so this is basically real life screen sharing. And these were around pre-COVID. I had the pleasure of using one of these courtrooms together while assisting Justice Ramesh, which was quite the experience back then. And so video conferencing, online virtual witnesses is all made easy in these courtrooms. And my own view is that, if you're thinking about the future and how courts will implement it, I think our court's quite there. I think our court has done exceptionally well on this front.
With all these differences between in-person hearings and virtual hearings in mind, I think we can all agree that professional and personal adaptations that lawyers and judges have to make are quite important. So my next three questions are for the both of you. Have lawyers and judges, for the most part, been able to successfully transition to conducting trials over Zoom? And what significant adaptations have lawyers and judges been required to make to the way they function in the courtroom?
Well, to answer the first question, the short answer is yes. As I've said, I don't believe there's a choice. Everyone has been either forced to or moved along in the wave of change. And this is, as I said, the new normal, and certainly even after circuit breaker. If you don't adapt, you risk being cast adrift. In terms of significant adaptations, I mean, it's very difficult to itemize what adaptations individual lawyers have made, because it's very individual specific. I would commend to everyone the portal Remote Courts Worldwide, which Professor Susskind had a hand in setting up. The portal was set up in response to the pandemic, and Professor Susskind describes the portal as such. This website, and I'm quoting from him, this website is designed to help the global community of justice workers, judges, lawyers, court officials, litigants, and court technologists to share their experiences with remote alternatives to traditional court hearings. So the portal actually provides valuable insight into the shared experiences of many in order for us to understand the adaptations that we need to make. I think that will tell you from a global perspective how people have adjusted to virtual hearings. And I think it's a very, very good read, and it's constantly being updated. And I do occasionally go on board, access the website to just understand how people are working out virtual hearings and whether there are any lessons that we need to take on board for our own purposes.
Yeah, absolutely. And my own view is I think lawyers have generally adapted well. We've seen quite a number of hearings. In fact, I think I've seen more online hearings this year than physical hearings, and for obvious reasons. And we see quite a number of practitioners online whom we once saw like submitting in person in court. And some of them online, they submit without breaking stride. The transition from physical to virtual seems almost immaterial to them. Their setups look clean on the screen. They look comfortable. You can see they're working as a team online. The delivery of arguments is as before. It is impressive, and I no doubt it required a lot of time and effort on the part of the practitioners.
Based on your experience with virtual hearings this far, you've seen some practitioners do better at conducting trials at virtual hearings than others. What are some of the more important adaptations you believe lawyers should focus on?
Well, I start by saying this. Effective remote advocacy is not a new skill set. The same skills that make for effective advocacy in a physical hearing apply. What the judge has to decide, how he analyzes the facts and the law to come to that decision remains the same. And therefore, the assistance of counsel in that process also remains the same. But there are some adaptations which are necessary because the virtual environment is different. First, personal preparation is key. I think Joshua has alluded to this. You must ensure that you have sufficient personal screens. It's not, you've got to ensure that there's sufficient screens before you, because if you don't, you might struggle with the way information is displayed before you as you advance your arguments. Second, you must not be flustered by technical glitches. These happen, and if that throws you off kilter, then it will disrupt the effectiveness of your advocacy. Third, you must be visible to the court. That's very, very important. In a physical hearing, the court can see you, you can see the court. It may not necessarily be the case in a virtual setting. The court must be able to read you as counsel and you, the court. Right? So body language and understanding non-verbal cues are so important in the art of persuasion. Right? And you must ensure that the setting and the way you present yourself to the court in a virtual environment facilitates that. Fourth, document management is important. Advocates must know how to manage electronic bundles and be able to quickly search for and access documents. Right? If you're struggling for information while in a virtual setting, that can be hugely disruptive. There are tools available, such as Opus 2, that can assist, and I suppose one can get the advice of people in this line who can tell you what's available for use. Fifth, interruptions and objections work differently in a virtual setting. In a physical hearing, you would signal your intention to object by standing up or through non-verbal cues. That's not feasible in a virtual hearing. So a speaking protocol is therefore necessary. Right? Lastly, channels of communication between lead counsel and the support team and the client need to be sorted out so that everyone can stay connected during the hearing. In a physical hearing, lead counsel will have his team and the client or client's representative in the courtroom. That will not be the case in a virtual hearing. There are several guides on how one can conduct a remote hearing, which are helpful. Some have been issued by leading arbitration bodies like the American Arbitration Institute. But one I found particularly comprehensive and germane is the guide jointly issued by the Ontario Bar Association and the Ontario Trial Lawyers Association, titled Best Practices for Remote Hearing. It's available online. If you search it, it will come up, and it's very, very comprehensive. I think Joshua will refer to another one in his response. Thank you.
Yeah, the piece recommended by Justice Ramesh is really handy. I mean, bearing in mind it is the effort of an entire bar association and lawyers association. I suggest another piece as well, and this is by one of our own in Singapore. Is entitled "Zooming into a New Age of Court Proceedings." It was released in 2020 on SAL Practitioner by current Justice's Law Clerk Aaron Yung, and it has insights from Justice Lee Siew Kin, as well as the President of the Law Society, Mr. Gregory Vijayendran, Senior Counsel, amongst others, of course. Aaron, in that article, he drew from his experience in a virtual trial with Justice Lee, which was one of the first trials conducted entirely online. And so, of course, with the court's permission, the perspectives of counsel were collated, the perspective of the court was collated, and this article was neat. And do have a read if you have time, because it contains many useful tips. I mean, as per the perspective of the court and the practitioners at the precipice of the turn from physical to virtual, and it gives you relevant insight on how lawyers have generally made the transition. I do not have much to add in terms of the adaptations. I think Justice Ramesh has covered those comprehensively. I simply add that, to me, the baseline really has to be comfort with tech, and ideally the use of tech, the familiarity, the interfaces, whether it's Zoom or Opus 2, it should become second nature, as intuitive as stepping into a physical courtroom. And I think lawyers of many years of practice, they know what to do when they step into a courtroom. They have their own mantras and practices, and that has to be the same for virtual hearings. And this will come with time, I believe. I just highlight one more point that Justice Ramesh raised, and this is on the speaking protocol. Absolutely, it is of utmost importance, because I believe Justice Ramesh as well, we have observed unfortunate instances where parties are talking over each other. Worse still, they are talking over each other. The court is trying to intervene, but because the way these platform works, the court gets drowned out by the parties back and forth, and it gets very ugly. And it gets worse in multi-party situations. For example, insolvency proceedings, where you can have dozens of creditors in the same virtual hearing. Like, imagine a Zoom room with 61, 62 creditors and parties. So establishing a protocol at the outset is very important. And there may be no universal or standardized court protocol from our end per se yet, but that really is because, as is the case for physical trials and hearings, the court looks at what the parties want, and the parties see what the court wants, or what the particular judge wants, and they run the trial accordingly. So different cases will involve different protocols, and it is important that, as with housekeeping, marking of bundles before trial in pre-COVID times, the fixing of a speaking protocol prior to substantive arguments must become second nature in today's hearings, because that will only aid all involved. It will reduce distractions from the oral advocacy, and most importantly, it will reduce distractions from the merits of the parties' cases.
So up till now, we have touched on quite a few topics, and Justice Ramesh highlighted how the issues with identifying non-verbal cues can also pose a problem when we are conducting virtual hearings. And this is where we zoom into the general issues with virtual hearings per se. And this question is for you, Justice Ramesh. Do the courts feel hindered in their fact-finding because of virtual testimonies? And if so, how have the courts prepared themselves to deal with this new challenge brought about by virtual hearings?
Well, I think the case law on allowing witnesses to testify remotely is well settled, and this is pre-COVID case law. You would, I'm sure, be familiar with the authorities. The courts have not found fact-finding more difficult in such a setting, provided the video conferencing capabilities are of a high quality. It can sometimes not be of the requisite standard, particularly where the witness is testifying from a location which is not fully equipped. And so that's not satisfactory. And in that situation, the court has to take a call as to whether the venue needs to be moved. So ensuring proper VC capabilities of the requisite standard is therefore vital. And that's where the test runs come into place, right? Because you need to do trial runs to see whether you are satisfied, broadly speaking, with what's on offer. And I would say at least one, if not two test runs to ensure that the facilities and the technology meets the requisite standards. And then you need to also properly plan for the hearing. Now, if these boxes are ticked, then usually there's not a problem for the court in terms of assessing the witness. But there's one aspect that is particularly important in a virtual hearing witnesses virtually, and that is ensuring the integrity of the testimony. Right? Supervision of the witness is obviously a greater challenge in a virtual hearing, as the witness is not physically before the judge in the courtroom. So safeguards are therefore necessary to ensure that the witness's evidence is not tampered with. Right? I cite three possible safeguards, and as I said, this is not comprehensive, and so just illustrations or examples. First, the court must know who is in the room or who is going to be in the room with the witness. So you need to have a pre-approved list of persons who may be in the room, And that list has to be directed. And before the hearing, you need to ensure that only those persons are in the venue with the witness. Second, there must be an independent party at the venue to ensure that matters are moving smoothly and being done properly. Usually, we would direct an independent law firm to undertake this task. And being lawyers, you would expect a certain level of professional commitment to ensuring things are done properly. Third, the court must be able to see and hear the witness clearly. So you must be satisfied that you have sufficient cameras in the room to see the witness from various angles, and also enough microphones to pick up whatever the witness is saying clearly. It can be, as I said, a challenge in certain instances, but by and large, I would say our experience has been positive. It's not been a problem for us.
And how has the court balanced the competing views of, firstly, implementing virtual hearings to curb the spread of the virus, and secondly, avoiding the situation where the impersonal remoteness of this entire process may be criticized?
I think the question presupposes that virtual hearings are impersonal, or at least less personal than physical hearings. This may not necessarily be correct. The fact is, remote hearings can be and frequently are as personal as physical hearings. Hence, Professor Suskin's point, which I referred to earlier, that we may not need to congregate in a physical setting all the time. And also the survey that I referred to reinforces the same point. As a baseline, or as a bottom line, how effective a hearing is very much a consequence of the quality of the discourse between the court and counsel, which is not necessarily related to the mode of hearing. In fact, many, if not most, of the hearings in the Court of Appeal, including criminal matters, have been virtual. I think that speaks to there being no compromise in the efficacy of the process simply because the modalities are different. I myself have managed several challenging applications. Joshua has referred to the insolvency matters as one category. Excuse me, involving multiple parties with no difficulty. In fact, in one matter, I had 55 parties on screen, and that tells you how what are the realms of possibility. Ultimately, it comes to discipline, it comes to proper planning, it comes to good behavior, and firmness of hand by the court. And then I would just conclude by referring to the Brunei trial, which I managed, where we were in 3 separate jurisdictions. There was Malaysia involved, and Brunei was involved, and Singapore was involved, and there was really no difficulty. There was a proper trial, and documents were done. I insisted on documents being handled electronically. So yeah, it's not a difficulty at all, provided you plan properly and you impose safeguards. Thank you.
And just to focus on another side of virtual hearings, one tenet of our judicial process is for proceedings to be open to the general public. And how have the courts facilitated public viewing of hearings for virtual hearings? And in what ways, if any, have virtual public galleries aided or impeded the accessibility of judicial proceedings to the public?
Right. So the question is only relevant only to open court hearings. Excuse me. Chamber hearings are meant only for the parties, not the public, unless the court directs the hearing to be heard in open court. Open court hearings that are conducted on Zoom are streamed on TV screens in the courtrooms. Members of the public may observe the proceedings from the public gallery of the courtroom, subject to safe distancing measures. If there's an overflow, you could have another courtroom designated for members of the public, and even some parties to observe the proceedings from that location. But unlike England and Wales, we have not introduced virtual public galleries or live streaming of court proceedings. Whether that will happen or not, I think that's we'll have to see. But that's where we are at the moment.
Speaking of the public and publicity, moving court processes online may have also raised unprecedented privacy and data security concerns. To the both of you, have the courts implemented any specific safeguards to deal with such concerns?
Well, security is an obvious concern. I mean, we all know hackers are there, and hackers have become very sophisticated. And quite honestly, technology is reactive to what hackers are doing. Zoom bombing may happen spectacularly, and this was seen actually quite recently in a high-profile bail application in Florida by persons posing as journalists with CNN and BBC. And actually, the whole hearing was completely unsettled and had to be adjourned as a result of these persons intervening. So to ensure security, and Joshua has touched on this, we have implemented strict protocols for Zoom hearings. All participants are assigned a meeting ID and password, which they have to use to log on. Once they've logged on, they're not automatically into the hearing. They're kept in a waiting room for verification before being admitted to the hearing proper. And then we have got guidance issued by the Supreme Court that audio or video recording of proceedings is not permitted unless authorized, and the court may actually require, may require an undertaking from counsel in this regard. And if you breach the undertaking, or if you proceed to record without permission, that is contempt of court. Thank you.
Yeah, I think I'll elaborate a little more on this point, and since it is one of the tasks that I've undertaken as a JLC in recent time. So fortunately, to my knowledge at least, we have not had any serious case of Zoom bombing in our jurisdiction, and hopefully never, of course. As Justice Ramesh mentioned, the verification process precedes the hearing, and that has required some changes to existing protocol. So for example, documents such as your attendance list, and they become even more important for security purposes. And in terms of verification, also in the early stages, we see problems amidst parties. I mean, myself included, we were less acquainted with Zoom. People didn't know how to set their names according to the convention. They didn't know how to turn on their cameras for verification. It was difficult. But I think today, everybody has been very well assimilated, and verification, as far as I can remember, has always been seamless for the past few hearings. In terms of local legislation, when we talk about the measures, and I think Justice Ramesh has gone into this in quite some depth, you look at statutes such as the CPC, they actually touch on some of the issues in terms of having independent parties present at the site of where the witness is in a foreign jurisdiction. And it is an important point that, you see, pre-COVID, our legislation actually contemplated these things already. But of course, in that context was in the context of online evidence and witnesses. And now we have all aspects online, submissions, all counsel, all witnesses, you even have clients dialing in. So as a matter of practicality, it is hard, if not impossible, to police everything. The court safeguard, of course, as Justice Ramesh mentioned, has been to administer before every virtual hearing the preamble and caution to parties and their clients as regards unauthorized recording. The wider and more effective solution, of course, involves cooperation of all the relevant stakeholders. On the solicitor's part, I think we as a court trust the members of the profession to act appropriately, and by and large, they always have. Parties and clients must do the same. And it's rather unfortunate. I've seen witnesses or clients, dialing in with their phones, which is not in and of itself problematic. But on one occasion, I saw a litigant driving while using Zoom on his phone right before a hearing was about to start. And you can see trees going past in the background, scenery changing. And then he picked up his phone, exited the car, walked around various people, walked back into his car. And yeah, it was alarming. And fortunately, this was spotted pre-hearing. And of course, we had to intervene for obvious reasons before the hearing formally commenced. When things like that happen, there's always the unpleasant last resort, which is even when evidence of such contemptuous behavior or unauthorized recording is discovered, there will be serious action taken. And as Justice Ramesh noted, this is contempt. But of course, we hope we don't get to that point. And I think this topic of privacy and data security actually brings into picture a wider notion of propriety and respect for the court, which is something mentioned in the Zooming into a New Age article that I mentioned just now. The general idea being that if in physical court proceedings, people are not inclined to whip out their phone to start recording, they should endeavor to observe the same decorum for online proceedings. And I suppose that in reality, it surely feels a bit different, and that is one of the struggles, collective struggles we have all had in this new age. But I guess I dare say that by and large, counsel, parties, clients, everybody has displayed high standards of like decorum and behavior, which is to their credit, and we have not had to step in on our end, thankfully.
And so now we are going on to the final question for today's interview. And this relates to the legislation that has been enacted in Singapore, which is the COVID-19 Temporary Measures Act 2020. Now, this act was created to provide temporary measures and deal with other matters relating to this pandemic. And Justice Ramesh, we would like to get your thoughts on the efficacy of this act in mitigating or even preventing disputes from arising because of disruptions brought about by COVID-19. And as the relief periods under the act for different sectors start coming to an end, what do you think the implications of this are going to be on the courts and or litigation? And how have the courts been preparing for the possible impending deluge of litigation?
Well, I think the act was necessary because COVID was unprecedented in terms of its consequence, not just to the economy, but also to the social fabric of the country. And of course, the global facet was also further negative impact on Singapore. The Act has been effective in my view. The Act has introduced 3 measures which are actually essential cogs in an overall carefully calibrated plan to ameliorate the economic fallout from the pandemic. The first is a moratorium against action arising from the inability to perform contractual obligations caused by the pandemic in 6 classes of contracts. Contractual obligations are, however, not washed away, they're only suspended. Relief is for a prescribed period. It was initially 6 months from 20th April 2020 to 19th October 2020. It has since been extended into next year. The moratorium has afforded businesses valuable breathing space. I think that was the real objective. People had to take stock, people had to assess because COVID was unraveling so many things, and itself was unraveling as a phenomenon as time went by. The second measure is a rental relief framework for small and medium-sized enterprises and specified non-profit organizations. Under this framework, the government and landlords provided rental relief for qualifying industrial and office tenants as one class and commercial tenants as another of 2 and 4 months respectively. So you had rental relief, and as a consequence, that resulted in cash flow relief, which is absolutely vital for struggling businesses. The third measure is perhaps most relevant to your question. With the moratorium coming to an end, it's important for businesses to find permanent solutions. The realigned framework, which is actually very recently passed by Parliament, is actually the third measure, and it addresses the permanent solution question in 2 ways. First, it provides a mechanism for MSMEs, micro, small, and medium enterprises, to renegotiate or exit certain classes of pre-pandemic contracts that are no longer viable because the business assumptions have changed as a result of the pandemic. There are qualifying thresholds, and there's a cutoff date for what is considered a pre-pandemic contract. Now, this is effectively a statutory enactment of the pandemic as an event of force majeure or frustration. The window of opportunity to take advantage of this mechanism is a small one. It is 6 weeks starting from 15th of January 2021, and you have to issue what is known as a notice of renegotiation. And once issued, you have 4 weeks to renegotiate or to negotiate and come to an agreement. If you can't come to an agreement within the period, and assuming the counterparty, the contract doesn't raise an objection, then the contract comes to an end. If an objection is raised by the counterparty on the basis that the qualifying thresholds have not been met or the terms being proposed by the parties seeking to renegotiate are not reasonable, then an assessor is appointed who then makes an assessment as to whether what are the terms of the exit, assuming the qualifying thresholds have been satisfied. There's actually a reasonable summary in today's Straits Times, and if you want further details, the Ministry of Law website is very helpful. It's important to note that this mechanism only relates to future obligations. So obligations which have already accrued remain unaffected and have to be performed. But it's also important from the court's point of view that the process doesn't involve the courts. So that's the first facet. The second facet is that, a second aspect is MSMEs that are unviable or that wish to realign and restructure their businesses may resort to a simplified liquidation or restructuring process. These are fast-track, low-cost processes with minimal court involvement. So this is not your traditional liquidation under the IRDA, the new act which has come into force, or restructuring judicial management or scheme of arrangement applications under the IRDA. This is a customized process, low-cost, fast-track, only for MSMEs. These processes allow qualifying businesses to move forward if they have a business case, or wind down if they don't, without incurring significant costs. And this is actually a very, very important function of an effective insolvency and restructuring regime, right? And at the same time, because it's an out-of-court process, or by and large an out-of-court process, it reduces the load on the courts, which I think is a very important and it's very benefit. Of course, as these matters are targeted, or these measures are targeted at SMEs or MSMEs, bigger businesses will have to seek recourse in the courts in the usual way. To address the anticipated increase in caseload, the courts have been examining various tools such as fast-track procedures, paper hearings, specialized lists of judges, simplifying discovery, active case management, and greater use of ADR, alternative dispute resolution. ADR, in particular mediation, has significant potential. In a recent application before me concerning 96 vessels, many of which were ocean-going super tankers, and all connected to the insolvency of Hindiang trading. You would have read about it in the papers, which is Hindiang is one of Asia's, in fact, I think it was Asia's largest oil trading company, and it has gone into insolvency together with its associated companies. I used mediation involving experienced specialist mediators with tremendous success, and the mediation resulted in the resolution of issues relating to 45 vessels. There were 96 vessels in total. 45 vessels issues were resolved. In addition, areas of disagreement with regard to the remaining 51 vessels were sharply narrowed, as a result of which the time that was required for arguments and for ventilation of views was significantly reduced. We actually disposed of the hearing within a day, which is a huge plus. I just would like to conclude by quoting Professor Susskind again. In the preface to his 2019 book, and it's a good read. I recommend or commend the book to everyone. The book is titled "Online Courts and the Future of Justice," which is actually what we're talking about, isn't it? But this is a book written pre-COVID. But I think the observations there are very apposite. Professor Susskind wrote, and he was writing about his granddaughter. And I will quote from what he said. It's very well said. "I often wonder what Rosa Susskind, that's granddaughter, will think of this book in years to come. Rosa, to whom this work is lovingly dedicated, is my first grandchild. She was born in early 2018 and joined us at a time of remarkable technological change. Projecting forward to, say, 2039, when Rosa will turn 21, I expect our world will be a very different place. In some ways, as alien to us today as a distant planet. Our society will have been transformed by some technologies that already exist, by others that are emerging, and by many that are as yet uninvented. Perhaps Rosa will want to know 2 decades hence why her grandfather felt the need to waste his time writing a book that argued for the glaringly obvious. That in a digital society, it makes sense for much of the work of the courts to be conducted online. I think these words ring so true. Change is really upon us, and change we must. Thank you.
Thank you so much, Justice Ramesh. And on that lovely note, our interview comes to an end. Thank you so much, Joshua, as well, for taking time out.